In Massachusetts, criminal defendants can be held without the right to bail for up to 120 days if they are deemed dangerous by the court. Now, the statute that allows for this is Mass General Law, Chapter 276, Section 58A. So this is often called a 58A detention. The way it works is the defendant will be arraigned, and if he's charged with certain crimes, which are referred to as predicate offenses, these are usually violent crimes such as strangulation, certain assaults and batteries and so forth would qualify for the prosecutor to file a motion asking for a 58A hearing, and at the hearing the prosecutor is going to try to show that the defendant is dangerous and that he should be held without the right to bail. If you look at the statute, it says, except for good cause, the prosecutor can have a 3-day continuance, and it's essentially to prepare for the hearing. So the defendant would be arraigned. The Commonwealth prosecutor would file the motion asking for the hearing, and then ask for 3 business days to essentially prepare for the hearing, for a continuance. Now, the defendant is held without the right to bail for those 3 days. So say this happens on a Friday, he'll be held until the following Tuesday. Many times, 58A detentions are denied. And often, though I think the prosecutors try their best to gather evidence, to get police videos, 911 calls, often they have none of that after 3 business days, and they simply come in and read the police report, which they had at the arraignment. So I think the defendant in many cases is held unjustifiably for 3 days. And prosecutors, this happened to me last week, prosecutors will say that they have an absolute right to that 3-day continuance, and even judges will say there's nothing they can do, the 3-day continuance is automatic, and it's not. There's case law that says very clearly that the continuance is a determination that needs to be made by the judge, and that the defendant has the right to be heard and argue at the determination hearing, which is basically the arraignment, though the defendant cannot present evidence or cross-examine witnesses. So the case is Commonwealth v. Lester L., and it's from the Supreme Judicial Court, and it states, "We conclude," this is the court writing, "that the continuance determination may be made after a hearing where a defendant is represented by counsel with the opportunity to make representations and arguments before the court." So it's not an automatic thing that the prosecutor should get this 3-day detention to send the defendant to jail for 3 days. And like I said, often the detention request is denied anyway, and very often the defendant does no jail time whatsoever for the crime. So this 3-day detention is usually the only jail time that the prosecutor gets, and often I think it's unjustifiable, and the defendant, at the very least, should be allowed to be heard at the arraignment and to ask to have the 58A hearing heard that day. So I've written a blog post on this, and I'll put it in the description below.